This is the first of the podcasts that I've made to support our study of the land law issues surrounding the ownership of the family home. The aims of this podcast are to explain the issue or problem that we're concerned with and to outline the ways in which the law could deal with the problem. The idea is that we should start to think together about how property law deals with the ownership of the family home and to see whether the law could be improved or made clearer. We could start by thinking back to the question about Alan and Emma that we saw in the first lecture. You might remember that Alan and Emma were in love and decided to get married. They buy a family home, but the legal title to the family home goes into Alan's sole name. They get married, and Emma contributes to the mortgage payments and other household expenses. She might also have made other contributions to the family by reducing her work commitments so as to look after the children. Anyway, the couple break up. On the face of it, the family home belongs to Alan since only his name is on the title deeds. This is a major problem for Emma, since the family home may well be the couple's only major financial asset. On the face of it, Alan is taking all of the family wealth, even though Emma made a range of financial and non-financial contributions to the well-being of the family. Indeed, since she made some of the mortgage payments, she has contributed fairly directly to the payment of the purchase price. You might think that the law would be unfair if it did not give Emma a share in the ownership of the family home. When the couple break up, shouldn't Emma be entitled to a payment that compensates her for the contributions that she has made? Should Emma be treated as a co-owner of the family home? And if so, what should her share be? Perhaps we can take it for granted that if Alan and Emma have freely agreed on how the ownership of the property is to be shared, then that should settle the matter. Ideally, this agreement would be recorded in the title deeds, but perhaps there is some other written or even oral agreement about their respective interests. Shouldn't the law encourage this kind of agreement? It would avoid later uncertainty and litigation. On the other hand, it involves disregarding the need for ownership interests to be created by some form of written document. So, if settling ownership by private agreement is favoured, the court should either 1. Give everything to Alan, since he's the sole owner, only his name is on the title deeds. If Emma's name is also on the title deeds, then assume that they both have an ownership share and look for evidence as to how they intended to share the ownership between them, or 2. Give effect to an express agreement between Alan and Emma about ownership, even though that agreement is informal and not shown on the face of the title deeds. But what if there was no agreement? How can the courts divide ownership, assuming that they think that it shouldn't all go to Alan? One way of dealing with this would be to divide ownership of family assets equally, or else to give the courts a discretion to allocate ownership of the property in such proportions as seem fair. This type of approach seems reasonable in that it makes the relationship between the parties the decisive factor, and the property was acquired precisely as a family home. Until their relationship soured, Alan and Emma may never have thought in terms of having separate shares in the home. Their thinking about the home cannot realistically be separated from the context in which it was acquired. Alan and Emma are married, and so the courts have discretion under matrimonial law as to how the couple's assets should be divided on a divorce. Where, however, the couple are unmarried, there is no such discretion. Instead, the courts have to apply property law rules when deciding how much each party is entitled to. Arguably, even here, the courts should place great emphasis on the fact that the property was family property. So in the absence of agreement, the court could exercise a discretion to give Alan and Emma equal or fair shares, to reflect the fact that property ownership was subordinate to the relationship between them. Another approach would be to give Emma a fair share of the family home that's proportionate to her contribution to the purchase price of the property. This makes the process of allocating ownership rights a fairly simple arithmetic calculation. Instead of exercising a wide-ranging discretion to do what is fair, the court could simply divide ownership between Alan and Emma in proportion to their contributions to the purchase price and mortgage instalments. This could be called the resulting trust solution. You might think, though, that this approach is unfair to Emma. Why shouldn't her contributions to other household expenses, not just the mortgage payments, be recognised? The fact that she paid household bills might be what made it possible for Alan to pay his share of the mortgage instalments. And what about the non-financial contributions that Emma has made? Perhaps she gave up her job to look after the children. Should that be taken into account in some way? Should she be paid retrospectively for the work that she put into the children's upbringing and any other jobs that she did around the home? Perhaps the calculation that only looks at contributions to the purchase price, up front or through mortgage contributions, achieves certainty and predictability at the expense of fairness and realism. Surely the court should take a much broader range of factors into account. This would be fairer and more realistic. The price to pay, though, might be uncertainty and lengthy litigation as the court sifts through all of the facts that might be relevant. So, if the court likes the resulting trust solution but feels that it should be more flexible, it could divide ownership between Alan and Emma by looking at financial contributions, but also take a broader range of financial and non-financial contributions into account. Arguably, this is, practically speaking, the same as possibility 3. That is, that arguably, this approach gives the courts the discretion to give Alan and Emma fair shares. The law of the common intention constructive trusts gives the courts the ability to mix and match each of these possibilities to suit the circumstances of the case. At different times in the historical development of the law, some solutions have been more in favour than others. The questions then are: 1. Do you think that the courts or the legislature need to develop a body of law that's tailor-made for the needs of unmarried cohabitees? And 2. Of the possible solutions mentioned earlier in this podcast, are there any that you favour or would definitely rule out? This slide shows some readings. They're just suggestions. You can read them at any time in the course that suits you.